Perfect. So in the interest of time, we're going to go ahead and run through this, and then I'm going to leave questions to the end. This is particularly important because we're recording this, and so I want your questions heard. So if you do have questions, just go ahead and note them, and I will take them at the end. So my name is Jessie Reams. I'm an attorney with the Northwest Immigrant Rights Project here in Tacoma. I was previously with the Northwest Immigrant Rights Project in our Wenatchee office. And so I've seen both sides of NWIRP, which is the detained side and the non-detained side. And today I'll be focusing my talk on asylum, and that we see in both the non-detained and detained context. Just as with Bill's presentation, this is going to be broad strokes. Asylum law is incredibly complicated and implicates a lot of areas of law, or a lot of sources of law. And so I don't expect you all to come out of this presentation being experts by any means, but there are some things that we can get under our belts in an hour. So let's go ahead and get started. If I can figure out the clicker. There we go. So these are the basics that I want to cover today. And by the end of this presentation, I hope that we can all answer this question. One of these questions we already answered, but for the interest of the video presentation, I'm just going to go through it again, which is the difference between an asylee and a refugee. And again, the difference being that a refugee is someone who has come into the United States already with status, whereas an asylee has been granted once they have entered into the United States. And so they're usually coming in as an asylum seeker first and then granted asylum through either a process through the United States Citizenship and Immigration Service or through an immigration judge. Who can ask for asylum? Well, a citizen wouldn't, generally, but it's anyone who does not have status in the United States or has a temporary status in the United States who fears return to their country of origin. When can you apply for asylum? Well, sort of any time, but we'll get into the nitty-gritty of that. How do you apply for asylum? Basic answer is there is an application called the I-589, which we'll go into more detail about. And that would be either submitted to USCIS or to the immigration judge. The last point, and this isn't really a question that you guys are going to have answered by the end, but just to point out that this is a rapidly developing area of law through both case precedents and through decisions that have come down from the Board of Immigration Appeals and the Attorney General. We've all seen a lot of changes in our immigration system in the last 3 years. Asylum is no exception to that. And the way in which we have approached cases has changed drastically since 2016. So there's two different asylum postures or procedures. The first is an affirmative application, which is an application that someone submits to USCIS when they fear return to the United States but are not in removal proceedings. The second is a defensive application, and so this would be when someone is already in removal proceedings before an immigration judge, and a application would then be presented to the immigration court. So some specifics about affirmative asylum. The application, which again is the I-589, and it is important to note that the application is the same whether you are in affirmative asylum proceedings or in defensive asylum proceedings, same form. And the form is not just for asylum, it is also for withholding of removal and protection under the Convention Against Torture. And so when you turn in that application, you're sort of applying for all of those things. One caveat is that an asylum officer, if you're applying affirmatively for asylum, cannot grant withholding of removal or protection under the Convention Against Torture. They can only grant asylum. So if you were to come into the United States on a B1, B2, a visitor's visa, and let's say you're from Venezuela, and I'm going to use this example a lot because this is kind of a straightforward in the news. I assume you all know the political situation in Venezuela, at least at a base level. So you have someone come into the United States from Venezuela on a visitor's visa. And they are afraid to return to Venezuela because they are part of a political party that is against the Maduro regime. And they get here and they're like, dang, like, it's going really bad back there. I don't want to go back. You know, I've had friends who have died there. I want to stay here. At that point, they can choose to apply for asylum within the United States. Once they do that through USCIS, they will eventually be scheduled for what is called an asylum interview. These asylum interviews are considered non-adversarial, and so that means that it's more of, you know, a question and answer session with an asylum officer. It's not the full-blown court experience. You don't have a prosecutor who is trying to disprove your claim of asylum. It is literally just an interview. In the Seattle area, these interviews take place at the Tukwila USCIS office, but it is important to note that we actually don't have an asylum unit within the state of Washington, and so asylum officers are flown up from San Francisco, which is the closest asylum office. If an asylum officer decides to grant your case, hooray, you're done. You would be granted asylum, and then a year from that, you would be eligible for a green card. If the asylum officer decides to deny your application, that's not the end of the road, and you have 2 bites at the apple. And so your case would actually be referred then to an immigration judge, and you would be issued a notice to appear in immigration court. At that point, you would then be eligible for withholding of removal and protection under the Convention Against Torture. So again, defensive asylum, it's the same application, the I-589. In the court setting, the government is assuming the role of a prosecutor and arguing against your claim of asylum. During these hearings, the individual applying for asylum has the right to present evidence in their case, and they have the right to present testimony, and the government has the right to cross-examine any witnesses that are presented. The evidentiary burden is higher, and the IJ ultimately then makes the decision whether to grant or deny. This is an appealable decision. The first step for appeals would be to the Board of Immigration Appeals. If a appeal is not successful at that level, it would then be to the Ninth Circuit and then to the Supreme Court. Defensive asylum, this is what we see a lot of in Tacoma. Individuals who are applying for this who have just arrived into the United States, or people who have been here for years but have never had an interaction with immigration and now fear return to their country of origin. And we're going to be sending out these slides, I believe. This is a really, and it's super hard to see, and I apologize for that, but this is a really good demonstrative of sort of each process of asylum. And so the top category, which is A, it describes what happens in the refugee resettlement process. It goes through the affirmative asylum process and then the defensive asylum process. So once you guys get these slides, I would encourage you to take a look at it. It's a really great infograph on the process and explains it very well. There is a special posture for unaccompanied children. So instead of falling into the affirmative or defensive camp, they kind of are on their own little island. When a child comes to the border and they are unaccompanied, they are put into removal proceedings, but the USCIS actually has jurisdiction over the application. And they would be the ones who would make the decision before the matter would be then set to a individual or set to a immigration court matter. With the USCIS adjudications for unaccompanied children, again, it's a non-adversarial procedure. That's even more so with children. They tend to have a special unit that actually comes up to interview kids. Kids are very difficult to interview, particularly when they've suffered trauma. And so thankfully, USCIS is somewhat sensitive to that fact. And so that's, I guess, a good thing. One note is that minors can be stripped of unaccompanied minor status if it's determined that they have actually been reunited with a parent in the United States. And so say they are, a child comes up and initially they are by themselves, they get designated by the Office of Refugee Resettlement as an unaccompanied minor, and when they are released on bond or released on their own recognizance, they actually reunite with a parent. Now, they go to the Seattle court for a check-in hearing, and the court is like, who's that with you? And the kid's like, that's my dad. The judge can actually, at that point, strip their status as an unaccompanied minor. And unfortunately, we've seen that happen. Previously, with these cases, we would ask courts to actually to administratively close the matter until USCIS had adjudicated the application of the child. Currently, they're not actually doing that, and so we just ask for rolling continuances until the USCIS has adjudicated the matter. So Bill went over some of this, but immigration law has a lot of sources of law. The big one being the Immigration Nationality Act. At INA 101A42A is where you'll find the definition of refugee, which we'll go over in a second. That's important because the definition for refugee actually gives us the requirements for asylum law. Regulations under 8 CFR are usually what we go by, specifically Section 208. And then there's federal court and agency decisions that we rely on. And again, we're in the Ninth Circuit, so obviously Ninth Circuit would apply here. Other sources that we use quite frequently, and this is kind of just to put in your back pocket if you do take a pro bono case, is looking at asylum officer training courses. So they're available online. They can be really helpful. I know it's kind of like using the other side's material in some regard, but they are helpful. Asylum officers are trained in the law, and so it can be a really helpful resource. Also, outlines and treatises, specifically the Ninth Circuit Asylum Outline is an incredible resource, and so I don't know who did it at the Ninth Circuit, but someone put together this great outline that has every Ninth Circuit decision that has come out on certain issues. It's really well organized and it's searchable. It's a great resource. Other resources that we use as practitioners are AILA's Asylum Primer, or we just use AILA Listserv, and for those who don't know, it's the American Immigration Lawyers Association. The other resource, which is basically our Bible, is Corresponds. It's very expensive, but it's very much worth it if you are practicing, and we do have copies at the office. Okay, and so as I promised, this is the definition of a refugee. And so we're gonna break this down because this provides the base for asylum law. So I'll read it out loud. Any person who is outside any country of such person's nationality and who is unable or unwilling to return to and is unable or unwilling to avail himself or herself of the protection of that country because of persecution or a well-founded fear of persecution on account of race, religion, nationality, membership in a particular social group, or political opinion. So we're gonna break this down. There's sort of three big things here. The first is a well-founded fear. And a well-founded fear is basically that individual has a subjective and objective fear of return to their country of origin. Subjective would mean they fear going back. Objective being that there's actually grounds for them to fear going back. So these are two things that, well, this is one thing with two elements that we have to prove in any asylum case. The next is persecution. And so this is a very fact-specific finding and necessitates an individual or a practitioner going into details about exactly what happened to that person in their country of origin and trying to fit that with case law or other sources that can show that that has been recognized as persecution by the Ninth Circuit or by the BIA. The last and probably the most complicated is on account of, or the nexus requirement, which necessitates that any persecution that individual has faced or fears facing is on account of or because of their race, religion, nationality, membership in a particular social group, or political opinion. And so if you are persecuted because your neighbor doesn't like you, to borrow from, I believe, Bill's example, that is not grounds for asylum. It can be as horrible as anything. They could have taken you into, their house and beat you silly and done all these things to you. However, if it was not because of one of these 5 protected grounds, no dice. So just getting in a little bit more into the nitty-gritty of this, what qualifies as persecution? And so, it's a legal term of art in immigration law, and so it's not easily defined. It is a threat to life or freedom or the infliction of suffering or harm in a way regarded as offensive. In the Ninth Circuit, we have seen many things qualify as persecution. Death, torture being an obvious one, but things like female genital cutting have also been deemed to be persecution, and significant emotional harm, such as death threats to oneself or to family members, as long as those are credible and serious. Also, the deliberate and substantial economic deprivation of an individual, and so an example of that would be someone who is in a very violent domestic violence relationship, and whoever is the persecutor of this domestic violence is making it so that person can't eat because they're not giving them money, or they're keeping them locked up so they can't work. And there's 2 ways to establish the fear of that persecution. The first, and arguably the easiest, is through past persecution. The reason why this is the easiest is because it, under the law, actually creates a presumption of future persecution. So in a case where you have someone who has already suffered a severe beating on account of their race, you are going to have a much easier time proving your case than if that person simply fears future persecution based on someone else's experience who is similarly situated. It's not to say that individuals who do not have past persecution cannot win asylum, but it's just to say that it is often much easier if you do have that past persecution, just because of this rebuttal presumption. Second way is by establishing a well-founded fear of future persecution. And this is give me one second. Had a good example for you guys. And so this can be developed through threats, actions towards individuals who are similarly situated, and country conditions. And I'm going to go back to the example of the political protester in Venezuela. And again, I'll be using this a few different times. So let's say that this individual was never physically harmed by members of the Maduro regime, but they are part of a political party, and they know people in that political party who have been murdered. And they have received threats from the government to stop protesting. And the country conditions show a pattern and practice in their country of individuals in the same party who have been tortured, killed, or disappeared. That would be a case in which it would be fairly easy to develop a fear of future persecution. Now, while that person themselves has not been touched by the government necessarily, we can easily foresee a situation in which they would be persecuted if they were to continue political activities. So the caveat to this is that the government can actually rebut the presumption of a well-founded fear. This would be through either fundamental change in circumstances or evidence that that individual could internally relocate within their own country. So going back to the Venezuela example, let's say that the Maduro regime falls and our individual who's part of this political party, their political party is now in power. That person's circumstances have fundamentally changed. They are no longer in danger on account of their political opinion. The other example would be that, and we see this as justification for denying asylum applications all the time, which is that Mexico's a giant country, you can likely go live in a different part where there's not violence. And so that's another situation where we see the government attempt to or actually rebut the presumption of a well-founded fear of persecution based on just ability to move to a different part of the country. So getting into the Nexus requirements, again, this is really just about tying the persecution or the fear of persecution to one of those protected grounds. And it did become a little bit more difficult after the Real ID Act passed on May 11, 2005, because now it has to be a central reason for your persecution. Before it was just a reason for the persecution, now it must be a central reason. So the evidentiary burden did become a little bit more difficult with that. So we're going to go through a few of it. We're going to go through political opinion in a particular social group. I'm not going to go into religion, nationality, and race, just because they are fairly simple. If you are to take a case through NWIRP, we would obviously provide you with guidance on how to navigate one of those situations. But the political opinion section and the particular social group tend to be the more complicated and nuanced areas, and actually what we see the most of. I don't think we see very many religious cases, or if we do, they're pretty cut and dry. Yeah. So for political opinion, an applicant can show a political opinion by the membership in an organization. They can also show it by refusal to join an organization or neutrality. So this is really important because not everyone comes to the United States running from persecution with a super sophisticated political opinion and an ability to articulate that. A great example of that would be, let's say you have a Honduran woman who she has seen everyone in her family abused by, every female member of her family abused by a man in their lives, and she has, had enough with domestic violence, and she is stood up for her right to live as a woman, and that we wouldn't necessarily ascribe a political opinion to that, but it is. It's a feminist political opinion. It is, the statement that women should be able to live as equals with men. And so even if an individual can't articulate a party or a position, that's somewhere where an attorney can come in and be like, well, this actually fits this model. And particularly when you're working with individuals who don't necessarily have high education levels or haven't been to college, it does become a very difficult thing to develop that case for political opinion if it's based strictly on, I belong to the X political party and was persecuted because of that. And the law does recognize that. So that's something to always be aware of. Political opinion can be actual or imputed, and what that means is that not only can you have the political opinion and be persecuted on the basis of it, but if your persecutors believe that you hold that political opinion, that would be grounds enough for falling into a protected group. We see this sometimes with individuals who are from Pakistan, who the entire town or municipality that they're in are of one political party, or in some cases one religious sect. To kind of borrow from the religion category as well. And based on those beliefs of that town, the Taliban or whoever will come in and destroy the town and persecute a number of people without asking them, like, hey, do you hold this political belief? That doesn't have to happen. We can obviously foresee a lot of situations in which that wouldn't happen. So that's important to note. And then getting to the, just a quick overview of race religion. So with race, I did want to note that it's not always, I'm Caucasian, that individual is African American. A lot of times it can be regional ethnicities and indigenous groups. And so we do see cases wherein individuals from rural parts of Guatemala and Mexico have been persecuted on the basis of their indigenous status. Within religion, you can also think about it not just as the capital letter religions, but also of sects of different religions. And so Shia and Sunni, we've seen cases where there's been different sects of Christianity and individuals have persecuted within those. And then with nationality, I don't think I've ever seen a nationality case. Have you? Yeah, they seem to be very rare. But like one example that I can think of is we recently had a intake for the Georgian woman from South Ostia. Oh, right. Yeah, so I'm really interested in Georgia. The country, not the state. And Georgia has the separatist nationality called the South Ostians, and I'm probably butchering the pronunciation of that. But they have basically developed this autonomous region within the country. Now, they wouldn't necessarily be considered a different race or ethnicity. They might say something different than that, but it's almost a different nationality. And so there's cases in which Georgians have persecuted Ostians based on that nationality affiliation. So I think that that's the only time I've ever come in encounter with it.
I think it was a lot more common also in the late 1980s with the Soviet Union and the dissolution of that nationality played a larger role in asylum law, but yeah, I wasn't doing asylum law then.
Yeah, neither was I. Wasn't born then. Showing my age, sorry. So the big and most complicated protected ground is particular social group. And one of the reasons why this is so complicated is because it's really ambiguous. There's not really a great definition from it. Circuit courts have different ways of interpreting this. We're just going to go over what the Ninth Circuit has said because we're in the Ninth Circuit, and we're lucky to be in the Ninth Circuit. So there's 3 requirements to qualify as a particular social group. So first and foremost, I'm going to give you an example of a particular social group. So we can start there. A gay man from Syria. All right. Well, let's do Pakistan because I know more about that. A gay man from Pakistan. So why this is a particular social group is because individuals who identify as LGBTQ have an immutable characteristic, so that they are an individual who belongs to the LGBTQ community. It also is a group that can be defined with particularity, so only certain folks identify as LGBTQ, and it is seen as socially distinct within the society in question. In Pakistan, there are laws on the books saying that men can be criminally prosecuted for being gay. So this fits all of these categories. And luckily for individuals who are in the LGBTQ community, this is a pretty recognized, and there's a lot of circuit law on point for individuals who belong to this community. Now, it becomes a little bit more muddled when you have a less tried and true particular social group. So one example that we've been working with a lot are women who are in domestic violence relationships from certain countries who are unable to leave those relationships. And so there, the immutable characteristic is that person is from a specific country, that they are female, and that they are unable to leave this relationship that they have with this other person. The argument would be that it is a defined group of individuals, and that those individuals are seen as distinct from society based on laws that are put in place to either protect them, whether they're effectual or not, or that the society views these women in a certain way. Proving this is quite difficult, as particularly the socially distinct part. Because in a lot of these cases, it's hard to say, okay, well, I'm going to walk into a room and I'm going to be able to identify a DV victim, from a mile away. That's not something that you're readily able to identify. But social distinction within the Ninth Circuit is not about being able to see the person and this distinct quality that they may have. It's really more about how it works in context. So I'm not expecting you all to understand this area. It becomes very muddled. This is something that we work a lot with pro bonos to try to develop cognizable particular social groups for asylum claims. And it sometimes does take a lot of work. And in certain cases where it's a shaky particular social group, we'll actually throw out, I mean, it's kind of a spaghetti against the wall situation. Like, I'm going to throw out every possible formulation of a particular social group and see what sticks, because a lot of these aren't recognized by the courts. And so it's a constant, it's an area that's rapidly changing. Within the last 2 years, we've seen changes to the domestic violence groups, and so the Attorney General, in his infinite wisdom, decided to, made a decision in a case called Matter of AB, which basically said that you couldn't define a particular social group based on the harm that they've suffered, and thus trying to preclude domestic violence victims from receiving protection under asylum law. Similarly, a few months ago, Matter of LEA came down, which is a case wherein again, the Attorney General, different one, they've changed a lot apparently, wherein the Attorney General, and this is Barr, said that family was not necessarily or not inherently a particular social group. And so we can walk through this one real quick. So a family, it's a mutable characteristic. You're born into a family or you're not, right? It's defined with particularity. You're part of that family or you're not. Now the part that stuck was the part that was at issue was the social distinction part. And so Barr basically said, unless your family is some highfalutin, like everyone knows them in the neighborhood type of family, they're not socially distinct. Obviously, we're arguing against this. We're trying to propose family-based defined particular social groups still, and we're still working at this. But for right now, that's been a huge change. It used to be, we'd find a family-based asylum case and we'd be like, jackpot, easy. This is, something that we can win quite easily, but that's not the case anymore. So strategies for Nexus, like I said, alternative theories. And so one that we see a lot is, taking that imputed political opinion and then, making some formulation of that with a bunch of different types of PSGs. And so again, the spaghetti against the wall, something may stick, and that's what we're looking for. It's also, when you're formulating these, you do want to define the category pretty narrowly. And so that's where you get into these like alternative iterations. And so going back to the gay man from Pakistan, that was actually one of my cases. And in that case, I proposed a particular social group of gay men from Pakistan, members of the LGBTQ community from Pakistan, men who have sex with men in Pakistan. And you can see that it wasn't necessary in this case, but just in the interest of covering my butt and making sure that this person had the best shot that they could have, it's really important to have those alternative formulations. Yes?
So one thing also, if you're taking a case through NWIRP, I think it's important to be mindful of this. When you get a referral, we will have basically identified what we believe the nexus will be, and we'll communicate that to you, so you don't have to jump from the very beginning and try and figure out what the grounds for persecution are. But it's great to know this because you might come up with other ideas, or you might see a particular social group in addition to political opinion or something. So it's really helpful to be mindful of this, but don't feel the pressure that you need to be experts on every little bit.
Absolutely. I mean, we at the office, we will sit around and, brainstorm these things together. And it's really, we're here to support any pro bonos that we may have on any of these issues. And throwing you into the fire to figure out your own particular social group would not be something we would do. So issues in proving cases. First is credibility. And so I'll just go over these real quickly, and then we're going to go into a little bit more detail about them. Corroboration, the state action requirement, internal relocation, firm resettlement, and return to country of persecution. So credibility, this does come up a decent amount because people's stories develop naturally, and because victims of trauma oftentimes have a very hard time recalling exact events. This is natural. There's been plenty of research that has been done on why that is, but sadly, immigration law has not necessarily caught up to that. Generally, the individual who is providing testimony needs to provide specific and consistent testimony. And unfortunately, again, with the Real ID Act, the evidentiary burden became even higher, and minor inconsistencies can be grounds for an adverse credibility determination, even if they don't go to the heart of the claim. So if someone makes, some inconsistent statement about something that has nothing to do with the torture that they experienced in their country of origin, that could still be an issue if they've made, a bunch of other inconsistent statements. One note is that if you are working with someone who has significant memory issues, it is a really good idea to get a psychological evaluation for that individual to prove or to at least demonstrate that that individual does have memory issues or trouble with recall. That can help in two ways. First, you can present it as another source of corroboration for your case. And second, there are protections that you can ask for before the immigration court that can help that person present their testimony. And so I won't get too into the specifics on that. If you had that issue, you would talk to Bill about it. But essentially, there are some procedural protections like asking leading questions only that can help people with bad recall actually tell a fairly consistent story.
Question?
Yes.
Who pays for that?
So, good question. So we do not have the funds to pay for psychological evaluations. However, there is an awesome organization called Northwest HHR. I never remember their acronym. Health and Human Resources, no, something like that. But anyway, we have a partner organization whose acronym is NWHHR, who actually is able to provide psychological and physical evaluations for asylum seekers. They don't work with everyone, and so there are some limitations on their own funding, but generally we're able to reach out to them to have that conducted. In some cases, people's families have paid for it as well, because it can be really, really crucial to the case. So corroboration is also a very difficult and important part of the asylum case. Unfortunately, a lot of people don't leave their country fearing persecution with a stack of every paper that they need. Turns out that doesn't happen. Also turns out that persecutors generally don't write letters saying, hey, I'm persecuting this person on the grounds of their race. Doesn't happen. So we're left with what we have. And in the detention context, that can be particularly hard because the individual who's detained oftentimes doesn't have ready access to phones, or they don't have the money to call to get declarations in support of their claim, and they might not have access to resources to get certain documentation in their country of origin. Basically, we do our best, and when we are working with a pro bono, usually we're not giving you a case where there's no documentary evidence. That would be cruel and unusual. So, but corroboration is very important, and an individual's testimony can be sufficient, but oftentimes the court will ask for more than that. And there is some case law on point, particularly Wren v. Holder, which is cited below. So if corroboration is needed, the immigration judge actually has to tell you what is needed and give you the opportunity to explain why you cannot get it if you cannot get it. And so there's been several hearings that we've had where the judge has been like, hey, in order to prove this, I'm going to need this, this, and this. And you can, at that point, ask for more time to gather that evidence or to explain why it's not available to you. So some practice tips: think of every person who could write a declaration, anyone in the country of origin. Again, this would be a point where psychological evaluations would be important. Also physical evaluations. If an individual has been tortured or been injured by their persecutors, there's often physical evidence of that, scars or broken bones. And NWHR actually can do those medical evaluations as well, and those can help corroborate an individual's claim. So the state action requirement, so that is that the harm that the person is suffering is experienced or inflicted by someone that the government is unwilling or unable to control. And so this would basically mean that the government is either so corrupt that they're not going to be able to actually do anything about this group of people that is persecuting your client, or that they're so underfunded. Usually we're able to prove this pretty easily through country conditions, and so that would be providing evidence through Department of State reports or through newspaper articles showing that corruption is rampant and that reporting to the police would be completely useless for this individual. Yes, it does. And fortunately, there's a lot of really good reporting on that. But unfortunately, being persecuted by a gang is generally not grounds for asylum. So kind of a hard situation there. But yeah. Internal relocation, we already went over this a little bit, but the idea that that person could actually avoid torture or future persecution by relocating to another part of the country. The important thing here is that it has to actually be reasonable for that person to do that. And this is interpreted differently by different immigration judges. But the idea would be that that person has no social network in a different part of the country, or they would have no opportunities to receive gainful employment. So there's a lot of things that you would want to brief in your pre-hearing statement to the court to show that this even if they could go to another part of the country, they would have no support, they would have no life, there would be nowhere for them to live. Funny story, my first ever asylum case, I had the prosecutor for the government try to tell me that my client could go to this one part of Honduras where there was no gangs. And so he pulled up a map and he was like, it's this part. And I look at it and I'm like, that's a national park. And so, it's one of those things where I don't think that my client is going to go hoof it in the national park, but okay. So there's a fun little anecdote. We won that case, thankfully, so didn't have to worry about it. She didn't have to go live in the national park. And where the government is the persecutor, there's a rebuttal presumption that internal relocation is not an option. This is pretty self-explanatory. If the government is the one that's actually doing the persecution, they're everywhere. You're not going to be able to hide from them, even if you're in a national park. Well, even less so there, maybe. Firm resettlement, this is an issue that we come into contact with a decent amount as well. And the idea is that if someone has resettled in a different country prior to the arrival in the United States, luckily in the Ninth Circuit we have some good case law on point that basically makes it so this person would have to have a permanent resident status or some other type of permanent status in the country where they have to be firmly resettled. So it's not merely that they went to Mexico and were given permission to stay there for 6 months. It would have to be that they went to Mexico and they married someone and got residency there, and that residency had no end limit. With firm resettlement, if an individual is found to have firmly resettled in a country, they are actually still eligible for withholding of removal and protection under the Convention Against Torture. So it's not the end of the line for that person by any means, but it does, if they aren't granted asylum, it does preclude them from certain benefits, including eventually becoming a lawful permanent resident or a citizen. Returning to country of persecution. So an example would be someone comes to the United States, and they apply for asylum, and they go back to their country for some reason. So they go back to Mexico and then come back into the United States. The reason why this is an issue is because it's basically undermining any future fear. Why did you return to the country that you had fear of going back to? And so things to look at or questions to ask your client are, how long was the stay? Where were you? Were you in the place that you have fear of? Who did you interact with? So those are things that can help you get over that hurdle of the undermining of future fear. So there's some other bars to asylum, and what's important with these are that, for the most part, if you're barred from asylum for one of these, you're actually still eligible for withholding of removal and protection under Convention Against Torture. Not in all cases, but in most of these cases. So the first one is the 1-year deadline, and so you have to file the asylum application, the I-589, within 1 year of your entry to qualify. And there are exceptions for certain circumstances, and so those have to be extraordinary or the situation actually changed. So we've seen that with people who have had severe PTSD, had no idea what they were doing, or were in a trafficking situation for a year and a half, and then finally released from that trafficking situation and then apply for asylum. And so there are ways to get over the 1-year filing deadline, but it is really important to get that application in. In the detained context, we usually, we can run into this, but if someone's a recent arrival, usually we're seeing them soon enough where we wouldn't. And if someone has persecuted people on account of the 5 protected grounds, they're probably not going to get asylum. I don't think I've ever encountered this, but I don't know if you have. I have. Oh, okay. Things like
that isn't going to get referred out.
Yeah, there you go. Material support of terrorism. So this one, unfortunately, does come up a decent amount, and that's because it can be forced material support of terrorism. And so if a terrorist group comes to you and is like, you must give me money, I'm holding you at gunpoint, that is actually material support of terrorism, which is ridiculous, but it is considered that. Again, probably not going to give a pro bono a case with this issue, but.
Not intentionally, but this actually just came up with a case. It was a Cameroonian asylum case that someone took that looked really, really straightforward, but the client had been robbed at gunpoint by a guerrilla group, and the government in the credible fear interview, when they interviewed the person at the border, actually alleged that it was material support of terrorism, that this person had basically was robbed, and they had a grocery store and gave the money out of the register, and that's material support of a group.
Yeah.
Yeah.
So I think I got out of order here. This is where. So the last one is Asylum Ban 2.0, which is a really futuristic name for a really horrible thing. So Bill went into a little bit of detail about this, but basically individuals who entered the country or sought asylum after July 16, 2019, and who passed through a third country are barred from receiving asylum in the United States. The exceptions to that are those who were metered at the border prior to July 16, 2019, and so I'm sure some of you are familiar with the parole in place policies of the Trump administration, and so basically they are counting people as they present for asylum and then turning them back to Mexico until their number comes up. And so if someone is metered, which means that they're given a number prior to that July 16, 2019, because of an awesome injunction, they are actually still eligible for asylum at this point in time. This could change quickly. What's up?
So the Ninth Circuit granted a temporary stay of the injunction. So they're not eligible for asylum right now. So unless, so it's back off, and Matt, who's in the back, is probably the expert because he just got a hearing with this issue.
Oh, okay. When did that happen?
Huh? November 14th?
Oh, yeah, you're right. Okay, yeah.
Okay, yeah.
Okay. So it's back on. And yeah. So basically that means that anyone in this situation who entered after July 16th is in this situation. Now, for pro bono attorneys who are taking cases, we're anticipating that this may change and that these people might eventually become eligible for asylum again. And so that's why if they are granted a different form of relief, whether it be withholding of removal or protection under the Convention Against Torture, that at that hearing you actually ask the judge to state the reason why they haven't granted asylum. And the hope would be that they would write on the order, I am not granting asylum only because of this executive order. And that when this changes, and the hope is that it does, that we can go back and reopen those cases and actually then win asylum for that individual. And if we have that on the record from the judge, it makes it a lot easier.
So for instance, an individual who comes from Venezuela will not face this issue because there's not, let's say that the flight is connect.
Yes, so if it comes in directly, but with folks from Venezuela, we often see that they actually fly into Mexico first, and then they're screwed. Yeah, exactly. So, but again, individuals in this who are in this situation still qualify for withholding of removal and protection under the Convention Against Torture. As Bill pointed out, those are higher evidentiary burdens, so that's one of the complications behind it, and you aren't going to get the full range of benefits that you get with asylum. So going into that, what are the benefits of asylum? First, indefinite status, and so your asylum status cannot be changed, and so even if you do not adjust to a lawful permanent resident, you are an asylee. The government could revoke that status if certain things happen, but barring any major criminal activity, you're usually good in that status for a while. You receive work authorization, access to certain public benefits, and you have the option to apply for spouse and unmarried children under the age of 21. You're able to travel with your refugee travel document. Unfortunately, you probably shouldn't go back to the country that you're applying for asylum against until you become a lawful permanent resident or a citizen. And even then, it's a little iffy, but that's a different story. All right. So as I said, there's two other things that you're applying for when you submit that I-589, withholding of removal and protection under the Convention Against Torture. So these are only, again, available in removal proceedings, and there is a higher evidentiary burden. The downside to withholding of removal and a protection under the Convention Against Torture is that you cannot generally travel outside the United States, and you don't have a path to lawful permanent residence or citizenship. And you also cannot petition for other family members at any point. All right, so looks like we're okay on time. I'm going to go through sort of the basics of applying for asylum in the court. And so again, it would be the submission of the I-589, or the application for asylum and for withholding of removal. This is the first page of it. It's, I believe at this point, a 12-page application that asks questions regarding biographical information, but also asks questions about the individual's claim itself. The I-589 is available at the USCIS website if you're interested in looking at it. And with affirmative applications, you would submit it with an original and 2 copies along with passport photo, and copies of passports and 3 copies of any supplementary evidence. For defensive applications, this would be filed again with the immigration court, and it can be either filed at a hearing or it can be filed at the window. In the non-detained context, it's pretty important to get this in as soon as possible for 2 reasons. The first being that we don't want to run up against that 1-year deadline, and so the sooner you get that application in, the better. The second reason is that in the non-detained context, when you submit an asylum application, a clock starts, and when that clock hits 150 days, that individual can actually apply for work authorization. And so it's really important to get that in as soon as possible. And again, this is just some information about the work authorization. You can file after 150 days. You're not technically eligible for 180. With the non-detained hearings, any applicant caused delays will actually stop that clock from running. And so if you present it in court and then you tell the court that you actually want a continuance to find something or to do something else with your client's case, the court can actually stop that clock and it wouldn't start running until that next hearing happens. And the danger being that you get it stopped at like 179 days and then it doesn't restart. And then that individual is all of a sudden not eligible for work authorization. For affirmative asylum interviews, again, they are usually conducted by officers out of the San Francisco Asylum Office, although they are conducted here at the Tacoma USCIS location. There is a last in, first out priority, so the idea being that the last folks that have entered into the United States are actually the first ones to get interviews. Weird, I know. But that's what they're doing, but we are seeing that they're getting scheduled. I mean, I don't know what the latest is. It seems like it's still pretty backlogged. And then the removal proceedings, sort of the breakdown of what happens in those is you would first have what is called a master calendar hearing. And these are preliminary hearings wherein you would review the evidence or the charges that the government has alleged against your client. And you would either admit or deny those allegations and concede removability. In the case of individuals who are applying for asylum, that's usually what you do. And you can ask for more time in those master calendar hearings if you've just taken the case and you need time to prep. Eventually, once you've turned in all applications for relief, you would be set for an individual calendar hearing, which is a merits hearing. This is where the full testimony happens. Usually in the Tacoma court, we're looking at time slots of 1.5 to 4 hours for individual calendar hearings, and in that time, you are, an hour and a half. You're expected to present all of your testimony in some cases, which is pretty hard to do. If an individual does receive asylum protection, they can actually petition for their relatives using the I-730. And again, this is the individuals who would be eligible for this would be legal spouses, unmarried children under the age of 21. And you're able to do this regardless of whether that person is in the United States or not in the United States. And it must be filed within 2 years of the admission. Some information on detained clients. We don't need to go through that, I don't think. So take a pro bono case. This is the time to do it. It's a very exciting time in immigration law, albeit sometimes depressing. Considerations with taking a pro bono case, first and foremost, time. Especially if it's your first case, it is going to take time. We will support you as best we can and as much as we can. Other considerations are language ability. We usually try to flag English-speaking clients or Spanish-speaking clients, for those of you who can't speak Spanish, for pro bono specifically because it does make things easier. You don't have to coordinate with an interpreter. And thinking about detained or non-detained, as Bill showed in his presentation, the rate of unrepresented individuals in the detained setting is much higher. This is a much more vulnerable population, and so it's a really important job that someone needs to do, and having pro bonos do that job is great for us because it makes it so we can take more cases. Also, one of the upsides to detained cases is they move a lot quicker than non-detained cases, and so non-detained cases can be stretched out for years, whereas detained cases usually resolve within a few months, which is a benefit. So if you know that you have time right now, but you're not sure about 6 months down the line, a detained case is likely the better option. All right, questions?
Why are some people in detention for 4 years? Is it because couldn't get their evidence together. And I also wondered why we see such high bails for people that leave detention. I read sometimes around the country it's 5,000 to 7,000, and here we see people with $25,000 in bail.
Absolutely. So,
To 40.
as to your first question, I think that it very much depends. We're with individuals who are in detention. They could be in a different part of the procedure than you might think. And so there's individuals who are in detention because they are awaiting a decision from the Ninth Circuit for a Ninth Circuit appeal. There are individuals who are in detention still because the government has failed to be able to produce travel documents for them. There's also individuals who have had their case go up to the immigration judge, and then they've appealed, and the BIA has remanded back to the immigration judge, and they've played this game of ping pong over and over again. And so there's many reasons why people are detained for long periods of time. For our purposes, when someone's been detained a really long time, particularly in the case of not being able to find travel documents, that is a problem, because that is constitutionally very much an issue when someone has been in detention for more than a certain amount of time and they already have a final order of removal. But it's hard to say why. It's case by case, and a lot of times it's because there's been this ping pong back and forth between the courts. In regards to bond, we're unlucky. I mean, I know that I have friends who practice in DC, and yeah, they're receiving lower bonds for whatever reason. Our judges have decided that $40,000 is a nice amount for people to pay who have no resources. So.
Yeah, bond data, this is on you.
Yeah.
Bond data is tracked throughout the country, and I don't have any reason for why, but Tacoma's court is tied for the highest median bond rate in the entire country, so they don't really. I feel like it's in like New Jersey or Connecticut or something. I saw it and remember reading about it, but I don't quite remember. Somewhere out east, though. So the observation, just to get it on the microphone, is that bonds from certain countries, such as India, tend to be higher, and I think that it's hard to say. And this isn't like anything grounded in fact. This is just kind of my little theory on it. But with the Indian community here, a lot of people have been able to pay really high bonds because there's a really tight-knit community in Kent, especially with the Punjabi community and the Gurudwara there. And if the judge is like, oh, this $35,000 bond and it got paid 2 days later, well, okay, we're good. We'll do it again. And I think there is like a little bit of a, if the judge believes that anyone can pay $30,000, then maybe it'll bump it up to $32,000 to make it a little bit more of a pinch on the person or whatever it might be. I don't know, but I think that the amount kind of gets desensitized by the judges, and we've seen it steadily go up. Like I felt like $10,000 was a really high bond when I started at NWIRP, and now I would be incredibly psyched to get $10,000. Yeah. Does every case get bond? No, that's a very good question.
Yeah. It
would be hard to estimate a percentage. I mean, it varies. There's a lot of people who just aren't eligible for bond based on a past criminal conviction or the fact how they entered the United States. Actually, talking about bond eligibility for arriving versus.
Yeah. So it's become even more complicated with the distinction of what proceedings an individual is placed in. And so if an individual is placed in, if they're an arriving non-citizen, they are placed in a different process than an individual that crosses the border without inspection. And that individual is actually who presents at the border is not eligible for a bond in front of the immigration judge. They are eligible to ask for humanitarian parole from Immigration and Customs Enforcement, but because of the type of proceedings they're in, they're not eligible for bond, which is sort of weird. And it's getting even more muddled with this, so withholding only proceedings are for individuals who have a prior order and there's a reinstatement of that order, and those individuals aren't eligible for bond until a 6-month mark. And so that's another situation in which someone just straight isn't eligible for bond until they've been in detention for a certain amount of time. And as Bill said, criminal convictions oftentimes can preclude, and so there's mandatory detention statutes, and so those have actually been expanded. Previously, you had to essentially be picked up right after release from serving time for that particular crime, and now if you committed it at any time in your life, you are mandatorily detained. And so that's been a development within the last 6 months that has really affected bonds. We're not seeing very many bonds at all.
Yeah, and just to back up to the earlier presentation when we were talking about cancellation of removal and people who have committed crimes that make them deportable, right now, effectively, no one who's eligible, you cannot be eligible for cancellation of removal and eligible for bond at the same time. Like if you've committed a crime that makes you deportable, you're not eligible for bond.
Yeah.
But I would say that probably the most absurd part of immigration law that I've ever found is, you know, the idea that if you come to the border, you walk up to an immigration checkpoint and say, hi, I'm trying to do right by the system, turn myself in, I want to ask for asylum the right way, fairly, you know, whatever, I'm not going to cross across the border. That person then is mandatorily detained and doesn't have a right to bond. But if their neighbor hops the fence and tries to sneak across the border, gets caught like 3 hours later, that person is eligible for bond. And I mean,
although they hold it against you in the bond hearing.
they do, but I mean, explaining that to people at the detention center it's hard.
Yeah.
It's just one of those things where it doesn't make any sense at all, but it's the reality of the system.
Yeah.
I had a question, 2 questions. There's a Lee court in Seattle and here at the Tide Flats. Do any people get tried in the Tide Flats that aren't in the center right then?
No. So it's only, well, yes and no. So there are individuals who are being held at other facilities, but who are detained by Immigration and Customs Enforcement. And so one facility is NORCOR, which is the Northern Oregon Correctional something, but they have a contract with ICE as well. And so I'm sure you guys have seen people who have been transferred to NORCOR. So that is a situation in which the person is not in the Tide Flats, but still would go to court in Tacoma. So they would either be, they're usually actually physically transported up just for that court hearing.
Okay.
But yeah.
And then the other one is, thank you, asylum officers. Who are they working for? Who's paying their paycheck, and how are they trained? So whose side are they on, and who's training them?
So they are employed by USCIS, or United States Citizenship and Immigration Service, and so it is then Department of Homeland Security who's paying their check. And so effectively, again, you know, the asylum interview is purportedly a non-adversarial procedure, and you know, in my dealings with the San Francisco Asylum Office, they often are nice people in some regard, and you know, some of them have like very good intentions, but ultimately they are employed by the Department of Homeland Security.
And those are the same people who are the prosecutors in an adversarial hearing,
Yeah.
a defensive case.
Are they lawyers?
Asylum officers do not need to be lawyers, no. And so oftentimes, it's actually funny, there's returned Peace Corps volunteers make up a large percentage of asylum officers, which is a funny fact. And, you know, interesting, but they do not need to be lawyers, although sometimes they are, so.
For those of us who have never been inside the detention center, I wondered if you could describe what life is like. And we've heard sometimes that people who have been in other detention centers like coming here, but we've also heard there have been food strikes here.
Yeah. Truthfully, I have never been into the nether regions of the detention center, only to the attorney visitation rooms and court at this detention center. I have done a tour of a GEO facility in Colorado. So GEO is the contractor who owns the Northwest Detention Center and who owns a lot of detention centers throughout the country and private prisons. They're separated into pods based on level of, and I think we'll go into this a little bit more with your presentation. But basically, it's a separation based on security level, and that security level is determined by criminal history and by a variety of different factors. It's bunk beds, I believe, and yeah.
So I have had a chance to tour the facility, but so the pods are like a long rows of bunks, and detainees spend a good chunk of their time in their individual pods. Detainee movement is something that is talked about, where there's certain times where people can move freely around the facility and other times when they can't. So kind of going back to Jesse's point that everyone is basically color-coded at the detention center as a means of security clearance. So, like, if you're blue, you're considered least dangerous. If you're red, you're considered most dangerous, and there's green and there's orange in the middle. And then for women, there's yellow for lower security and pink for higher security. So there is kind of that color coding and
gendered color coding.
And gendered color coding, yeah. But the colors are not really allowed to mix. This isn't like a painting class or anything. So basically like a blue and green people can be in the hallway at the same time. Green and orange can be in the hallway at the same time. Orange and red can be in the hallway at the same time. But males and females can't move throughout the facility at the same time. And so if your one client is in blue and your other client's in red, they will never meet in the facility. But because of that, there's certain times where movement is happening for people wearing a certain color uniform, and during that time, if that's not your color, you don't get to move. So you're just stuck in your pod and you're not free to move. People have 1 hour of recreational time a day, which is outside time, and by outside time at the detention center, and albeit it is the Pacific Northwest, it is a room with 3 walls and a chain link fence on the other side, so you get to see the sky, but you're not really outside either. And then most everyone at the detention center tends to work just as a way to alleviate boredom. It's very cost effective for GEO that a lot of the janitorial duties and other random things, they don't have to hire people to come in. They get people to do them at the detention center, and they're paid $1 a day into their commissary for an 8-hour shift. I think the complaints that we hear most often about the detention center are the food, the quality of food, and the quality of medical care. I think those are the biggest frustrations, and we have seen cases, like a case that Paula and Joan worked on, where an individual who was quite sick received very good medical care. But a lot of times people will come with complaints, and they'll get like a little cup with some aspirin and then be told to go back to their pod, no matter what, I kind of think, I don't know if people have seen that movie, My Big Fat Greek Wedding, but I kind of picture like the guard just like spraying Windex on people and saying they're good. But basically it's pretty, it seems like the biggest challenge is, I think, we hear complaints about the food and the medical treatment, but just the isolation is the hard part, especially for people who've been in there for a long time.
What about access to the legal library or phone calls?
Yes, so in terms of getting access to the law library and phone calls, so there is a law library available for detainees, so they can access a computer, they can research information, case law about their cases. Some people take more advantage of that than others, but because of restrictions of who can access areas at the detention center at any given time, people have to make appointments to be able to go to the law library, and so it can be challenging if you have a filing deadline coming up in your case and you can't get that appointment, or you have to pick between, like working your shift or possibly losing your good job at the detention center and having to do a crappier job, or whatever it might be, with the opportunity to like go there and look at a computer and try and look something up that might be important for your case, whether you'll find it or not. So it can be a challenge to access it, but not that big of a problem. Like generally, people can make appointments to go to the law library. There is no internet access there. They're not. I mean, no, they're not. But by government, I mean, there are issues with it. But I mean, in terms of what's in there, it's hard for me to say, because like when you do a tour of the detention center, you don't get to go pour through what's in the law library, so we just hear a lot of it secondhand. And then in terms of phone calls, we can get clearance so that phone calls to attorneys or to representatives such as us at NWIRP, we can get cleared through ICE so that they can make free phone calls to us. Phone calls to family members come out of their commissary, so if they don't have someone paying money into their account, or they're trying to make an international phone call to a family member in another country to say, hey, can you send me this document? It's really hard because international phone calls are expensive and you're only making $1 a day and you might not have come here with much money. So another way that attorneys can be critically useful is, again, corroborating evidence is important. It's really hard to get when you're detained, but if you have an attorney on the outside who's willing to try and call that family member in Cameroon or Venezuela or whatever country it is and have that conversation to be like, look, we need these documents, and you don't have to send them via DHL to this address at a detention center. You can scan them and email them to me, and then you can get them pretty much instantaneously. It makes a huge, huge advantage.
I've found WhatsApp to be a super helpful app
Yeah.
in that regard, because a lot of people in those countries don't have access to a scanner or just don't use email, and with WhatsApp they can just take a photo. So I would recommend downloading WhatsApp and setting up an account.
So Matt recommended WhatsApp, and I completely agree. It's super, super helpful.
It's also encrypted, so but somewhat. Exactly. So that's one thing to consider as well.
And also to keep in mind, the phones at the detention center can be monitored. If you are having a conversation, or if a client's having a conversation, ICE deportation officers can listen to those. As an attorney, your conversations with your client are still covered under attorney-client privilege. So it's important that you either you can contact ICE to ask that any phone calls to your line are not recorded or listened to, or you just make sure that you're very clear every time you talk to your client that, I am your attorney, we're having this conversation, it will be confidential, and then basically if someone's listening on the other side, they should stop listening at that point because they know it's against the law.
I read recently that there's standards for operating detention centers, and one of them was that you're supposed to make one phone available for every 25 detainees. And I'm thinking with 1,500 detainees at the Welcome, the detention center, I can't believe they're providing that many telephones.
So the comment was whether or not there are enough telephones for detention standards of 25, or one phone for every 25 detainees. Truthfully, I don't know the answer to that. Each of the pods, which probably house 70-ish, I feel like somewhere between 50 and 100 people in a pod probably, just from looking at it and guessing. There's a little bank of phones in every pod, so I wouldn't be surprised if that's actually okay, because if there's at least 4 in a pod, it should be okay.
Well, and they're making
And
money
I
off
haven't
of it.
gone and counted.
So, that's, the other consideration is like access to phones. Quality of phone calls have been an issue, I think, more than actual access to phones. And it's also, obviously if someone can't afford to call, then we're in a different situation. But yeah, I don't think that I haven't heard any complaints about actual just access.
No, nor have I.
All right. Is there any other questions regarding asylum or asylum adjacent things? If not, I think we can go ahead and take our break right now and get started a little bit earlier then. So let's be back here at 3 o'clock to get started on the next section.